it looks like then all the technical pieces are in place. So good afternoon, welcome to today's colloquium. The MENAS colloquium today is Holy Places in Israel and Palestine, an overview of legal regulation with Dr. Leonard Hammer, who is currently the David and Andrea Stein Visiting Professor of Modern Israel Studies at UA Center for Judaic Studies. He's also an adjunct professor at Hebrew University's Rothberg School and serves as the academic director of Shurat Hadin, the Israel Law Center, which is an Israeli-based civil rights organization. And he works as an international expert for the Open Society Institute. Dr. Hammer's most recent publication, a co-edited book, is Sacred Space in Israel and Palestine, Religion and Politics, and it was published just last month by Routledge. Dr. Hammer lectures in the fields of public international law and international human rights, and has published books, articles, and chapters pertaining to these topics. He has received a number of fellowships and grants to conduct research on international law, freedom of religion and conscience, migrant workers, and holy spaces. In today's talk, he will examine varying approaches to the management and regulation of holy places in Israel and Palestine, emphasizing current approaches to controlling such sites by the Israeli authorities, and also consider various legal sources related to the regulation of holy sites, including the regulatory status known as the status quo by Ottoman authorities. So please join me in welcoming Dr. Leonard Hammer.
Thank you. Well, it's really a pleasure to be here, and I appreciate you all giving me the opportunity to offer you a lecture about this. I thought this is basically, I've been doing research on holy places in Israel and Palestine for about, it's now coming up on 6 years. I always say 5 years, but now it's coming up on 6, and I probably run over to a couple more years. And a lot of the work, my background is I am a lawyer. Never practiced, but that's what I studied. So my background is more of a legal orientation, and the truth is part of the impetus to engage in the holy places, and I work a lot with a professor from Catholic University by the name of Marshall Brieger. We've done a lot of work. That's basically what we've done together. He was one of the co-editors of the book, and we sometimes throw in other individuals from either side, either an Israeli or a Palestinian, to assist with to create another type of publication. We're actually now going to do one on Italy, Italian holy places. But the impetus was that there was a lack of, if you will, I won't call it an understanding because that would be unfair, but there was a lack of a examination of the laws that pertain to, and regulations that pertain to holy places. And it's kind of insightful in its own right, and obviously it's going to incorporate a whole slew of factors beyond just law, but also social factors, cultural factors, and different things that we'll examine today. So I thought that today would be nice to offer an overview of the legal regulation. I hope it's not going to be too dry. You have to tell me at the end, okay? I beseech you to tell me if it was too dry. But it should be somewhat interesting. And of course, we'll start off with the status quo. The status quo was actually emanated from a firman during the Ottoman Empire. Firman issued from Constantinople, now Istanbul, from the Mufti. And the notion is that as the Ottoman Empire was crumbling, I hope you guys don't mind, I'm going to sit and stand every once in a while as well, just to get comfortable. Small audience, we may as well be a little bit more informal. As the Ottoman Empire was crumbling, there was a desire to engage some of the Christian the Christian states of Europe, and allow for them and provide them with some type of if you will, assurances that there wouldn't be problems with the key. Opa, I just spilled the water. I knew it was going to happen. That's why I put it on the other side, just for the record. So, there was to provide them with the key, to provide them with some type of assurances with regard to how the Christian sites would be treated, and in a way, it was one was pre-Crimean War, and one was post-Crimean War, in dealing with, for example, issues of the Holy Sepulchre. Because what was happening was that over time, the key Christian sites, which I'll show you what were covered in the status quo in a second, were crumbling, were falling apart, and every time that the ruling authority, and this is from the Ottoman Empire through the Mandate through till today to Israel, would attempt to engage any type of, let's say, repair or assist with even, and providing financial assistance even, and physical assistance to assist with to repairing these crumbling structures, they'd be met with this severe resistance principally due to infighting among the different Christian sects that existed at the time. So they came up with the status quo, and this is a quote from one of the Firmans. I think it's from 1876 or 1878. Forgive me if I'm not exactly remembering the exact date, but actual status quo will be maintained. Jerusalem shrines, whether owned in common or exclusively by the Greek, Latin, and Armenian communities, will all remain forever in their present state. So that's really bold language, all remain forever in their present state. Of course, the present state is not physical, but in the sense of how they conduct themselves. And in a way, the status quo is carried through till today. It's a very interesting study by a guy named Raymond Cohn. He just published a book, I believe, about a year ago on the Holy Sepulchre, which is obviously one of the key status quo sites. They're listed over here, so we'll just skip a slide to show you what we're talking about. The Holy Sepulchre, Dios Sultan, Sanctuary of the Ascension, Tomb of the Virgin, Church of the Nativity. And it's actually, what it did is the status quo provided for some type of operative framework that allowed the different sects to engage one another, because they were literally fighting. We still have that even today in Israel. For example, the Holy Sepulchre, when you have the different types of what do you call it? Different types of prayer rituals, passing of the fire, and different things around Easter time and around Christmas time. Sometimes they really resort to fisticuffs. I mean, I'm not exaggerating, where they're hitting each other. Which is not to denigrate, but it's more to say is that this is serious stuff to these guys. To the extent that in the Holy Sepulchre, for example, in Raymond Cohn's book, it's actually quite interesting, where he asserts that over time you can see that they've come to agreements among the different sects. Be it as it may, the significance of the status quo was that it froze the rights. So whatever right you had, for example, if you're the Ethiopian Christian sect, you might have the right of sticking the key into the gate that leads to the roof of the Holy Sepulchre or the roof of the Deir Sultan, and then you might be if you're of the Coptic, right, you have the right to turn that key, and then another sect might have the right of opening the door, believe it or not. It's really to that extent the status quo has really been developed. But the idea is that it freezes the rights, it freezes the capacity for action. This is what you can do, and it's frozen in that period of time. Obviously, well, not obviously, but during the period of the Ottoman Empire, the Greek Orthodox Church actually had an upper hand in a lot of different things with regard to property, as well as with regard to the ear of the Sultan, of the Mufti at that time, I mean. And they were extremely politically shrewd, the Greek Orthodox, during this period of time. So they kind of have a lot of rights under the status quo. And it also provided for positions jurisdiction. What I mean by that is, and it's not to get too legal, so don't get nervous, but what I mean by that is that the idea of the status quo was to say, we don't want necessarily courts. We don't want necessarily the different sects to run to courts all the time and say, hey, I have a right of doing that. I have a right of lighting the fire, and you have the right of carrying. And I saw you light the fire and carry it, and therefore I'm going to challenge you before the court. And we'll see how that develops with the mandate time, that it was trying to remove, in a way, the reference to or jurisdiction of the court system itself, to avoid from having these conflicts, and saying is they're frozen in time and that's the way they're going to be. That's the implication of the status quo. A link to the Millet system is just a reference point of demonstrating the Ottoman Empire as a rather, if you will, tolerant form of empire, allowing for a variety of different religious systems to coexist. And the incorporating into international law is actually quite important. And there what I mean by that is that the status quo, the Firman itself, is actually referenced in a variety of subsequent treaties. After the last Firman that was issued, and as I said, in the 1870s sometime, 1878, 76, Treaty of Berlin references it, the Congress of Vienna references it. And it's subsequently been, as I said, incorporated into the lexicon of international law, that the reference to the status quo implies something. The implication being is that the rights are frozen and that the jurisdiction is limited, meaning the jurisdiction of the state. So we'll see as a result, Israel in particular, and the mandate also, were very hesitant to get involved in any type of status quo issues. Now, the British added on to the status quo, before we get to the actual British context of how they operated with holy places, because they obviously broadened it, but the British added on to the status quo. What they had is they did a study by L.G.A. Cust, who was I believe, a British general, and I think he actually ascended to becoming a lord. He came over to Palestine, at the time, in the early 20s, so it's the beginning of the mandate, and he actually published a book, which you can still get. It's in English. It's about this thick. It's about 80 pages. And what he does is he goes through the different rules with regard to the status quo as they developed over time. So in other words, while the Firman itself was this generalized edict saying his rights are frozen, nothing can change, what emerged was that the three principal parties, meaning the Armenians, Franciscans, and the Greek Orthodox, and then of course allowing for the other parties and whatever actions that they were allowed to do under the status quo, they actually outlined them in a really formalized manner, to the extent that you could go today to the Holy Sepulchre, for example, and they even have maps. The maps are hilarious because they're kind of color-coded. I think it's red, green, and I think blue or yellow. I forgot the third color. And I say it's funny because you might have a wall. Let's say this is a wall where this is the Franciscan side and this is the Armenian side. On the color-coded, they'd have red here and blue here, or red here and yellow here, just to show you how they really divided up literally centimeter by centimeter to allow for who controls what and how things can be done. And the importance of it is, for example, just to show you the complexity of the status quo, in the Holy Sepulchre, when they wanted to allow for example, more to modernize the restrooms, the toilets that were in the church itself, as a result of influx of tourists. So they had to cut the pipes through different sects' portions, and some sects weren't allowing it to happen because they felt it was an infringement on their right to cut through and create bigger pipes and newer pipes, whatever it is, different systems. And again, they actually tried to get Israel, in this case it was about 10 years ago, they actually tried to get Israel involved, for example, in this, and Israel didn't want to, again, because it was a status quo site. It was out of their, if you will, jurisdiction. So there's benefit to the status quo is in that you don't have so much of an involvement, if you will, by the surrounding power to interfere with, let's call it religious freedom. But by the same token, it can also lead to freezing of different things that need to be done, like new restrooms, fixing a window, things like that. There were instances during the mandate, as well as when Israel, post-1967, when Israel took over the old city, and that is that there were times where the state, Israel, just went in and did it anyway. And the mandate did the same thing, because if a roof was collapsing, and the sides literally couldn't agree, so Israel would go ahead and fix it and then say, look, if it would collapse, it would create even more tension. I wouldn't say world war. I don't think we're at that same stage as we were in the Crimean War era. But that Crimean War partially started because of the issues with the Holy Sepulchre and fixing the Holy Sepulchre, by the way. That's not the only issue, obviously, but that was part of the reason why it started, was it created tension among the Catholic, the variety of different Catholic countries. Well, Cust also added on two things. The policy of the mandate was not to deal at all with any Muslim religious properties, not to touch it. It was totally autonomous. With regard to Jewish properties, what they did is, at the time, they made changes with regard to the Western Wall and Rachel's tomb and incorporated that into the status quo arrangements. The Western Wall was they allowed for Jewish prayer during the Day of Atonement and to blow the ram's horn at the end. And Rachel's tomb, they also allowed for some type of Jewish prayer to go on there, for Jewish access to the site, I should say, at that time. In essence, that was adding on to the status quo aspect that Cust did. In other words, in the book that he published about the status quo, he also says, and we're making allowances for, and he kind of sloughed that into the notion of what the status quo was. So that was just another angle that was added on by the British with regard to because at the time, I should add, at the time in the early 20s, there was major tension with regard to the Western Wall in particular, and they felt that there was a way of appeasing some of the Jewish interests at the time with regard to use of the Western Wall. And then they listed other types of things. No chairs are allowed there, and different things that they know prayer was allowed there at other times of the year. Things like that. They kind of laid down different rules that they thought would appease both sides. As you know, the British kind of stood on the fence during the mandate, tried to please everybody at once, and of course nobody was pleased. But that's the game of politics. So that was the status quo aspect during the British time. Now, the Article 13 of the mandate and Article 14, which we'll get to in the next slide, establishes expands upon the need for some type of legal structure with regard to regulating key holy sites. And what I mean by that is, prior to that, there wasn't much by way of, if you will, not even protection, but engagement in any type of legal sense with regard to how to address and deal with the different holy places that might have existed in the Holy Land. So all responsibility in connection with holy places, religious buildings, including securing free access, and free exercise of worship, ensuring for public order, provided also that nothing in this mandate shall interfere with the management of the purely Muslim sacred shrines. So they say is that, sorry, I was saying, and the free exercise of worship, public order, is assumed by the mandatory. Sorry, I missed that one out. I knew I was missing out. Is assumed by the mandatory, right? So the mandate is saying is that, okay, we're going to take on ourselves for some type of responsibility, and of course allowing for free access to holy places, all right? And then look, they put aside as they don't interfere with the management of the purely Muslim sacred shrines. Okay, so they're putting aside the Muslim shrines. They don't want to deal with that, but they are saying is that we're going to take over, deal with some way, allowing for, notice the two key rights here is exercise of worship and securing free access. And that's going to ring, this notion is going to ring loud throughout the rest of till today, the idea of access and worship. And the reason why it's going to ring loud is because it's reflective of, at least in today's context, as some of my students here might know, is freedom of religion and freedom of religion and belief in the context of the international human rights. That is, in essence, what is provided for. Freedom of religion or belief in the international human rights context is rather limited, rather narrow, I should say. And it really does essentially deal with notions of practice which are focused on worship or access where it's a manifestation of a belief. So the right is actually quite limited. Nevertheless, you could see the beginning of those type of notions of access and worship as being the Grundnorm, as being important concepts by which the rights are secured. And then we'll see in Article 14, a special commission was to be appointed to study, define, and determine the rights and claims with the holy places. Notice, of course, the, and then capital H, capital P. So it's referring to a particular notion, a particular concept of holy places that are of, if you will, paramount importance. Meaning they're not within the status quo, because the status quo is kind of dealt with already. It's kind of addressed already. Status quo is there. They're upholding the status quo. But there's also other notions of holy places, capital H, capital P, that have to be dealt with. And they were meant to set up a special commission, which was never established. All right? Now, what happened was when they saw that they couldn't set up that special commission, they passed a law, Order and Council. Order and Council were laws that were passed under the aegis of the mandate, of course, approved by approved by Great Britain. And the idea is as follows, and this is what I was talking about with regard to jurisdiction, because the mandate authority saw right away that if they would allow for some type of dealing with aspects of holy places, that they'd be opening up a Pandora's box that they could not retract themselves from. So what they did is they said, well, we want to set up this commission to deal with holy places. In the interim, we can't set up this commission for a variety of different reasons, mainly political, I should add, mainly political. And that was who was going to control the commission, how it would be composed, which orders, which sects would be included within that commission. So they said there's no matter in connection with holy places, no capital H, capital P. So they're not talking about, they're not talking about some, small little church or small little synagogue, but they're talking about key holy places. Think Mount Tabor, Tomb of the Place of Resurrection, stuff like that. In connection with holy places or religious buildings or sites, soon to notice historical relevance. So they're trying to define what they mean by these capital H, capital P type places, those with historical relevance and the degree of veneration according to it by humankind in general. Sounds really nice, doesn't it? But it's the degree of veneration. No matter shall be heard or determined by any court in Palestine. Shall not be. All matters referred to the High Commissioner pending the constitution of a commission. So what are they saying here in essence? They're saying is that these matters shall not be heard by a court, but shall be referred to the High Commissioner until there is a commission that's established that's meant to deal with the holy places. So what that implies is, or at least looking at extrapolating from the position of the High Commissioner is an executive branch type of context. It's not judiciary, and it's not necessarily legislative. The High Commissioner was there to execute the laws that were passed by the mandate, Order and Council. And I'm emphasizing that because in a way that's how it's been interpreted. This particular Order and Council was carried over into the Israeli legal context as well. The High Commissioner as emanating from somebody from the executive branch would be dealing with these type of issues. But the key thing is that it removed the jurisdiction of the court to deal with issues regarding holy places. Okay? No matter. It's a very kind of a broad type of notion. So this means is that there's no judicial jurisdiction and this application of special protection to key sites. That's really the implication of that order in council. Because the Brits saw kind of quickly, you notice it was 1924, so you're talking about maybe 2-3 years into the mandate, they saw pretty quickly, A, is that no commission was going to be formed, and B, they're going to have major problems with these holy places, with these holy sites, capital H, capital P, specific ones, big ones, important ones. Senecal, for example, is another good one where the Last Supper took place, right? If you notice, Senecal wasn't in the list of the status quo places. That's why I put it up there. The list, I mean, not the Senecal. And yet, obviously, it's an extremely important site. You know, you're not dealing with like just a church that's being built haphazardly. These are important places. Mount Tabor is another important place. It's where Jesus went up, I think, on the first time. So you're dealing with important places that they're recognizing that you don't want to have judicial jurisdiction over that. Why? Because you want to have some type of, shall we say, political power, somebody with political position, savvy, who is more, if you will, can ease around regulations, has more capacity to make decisions, not necessarily linked to the law itself. Whereas obviously a judge is meant to be objective, and objective application of the law. And once you have it written in the law, well, there's nothing we can do about it. In fact, we'll see that's part of the issues that are dealt with in the Israeli context when addressing some of the holy places, and certainly the status quo places. But the point is that they recognize that there had to be some type of special protection for these sites. The 1924 ordinance still applies in Israel today. What happened was that Israel, when it was established, not going too much into the background, but Israel, when it was established, basically adopted whole scale the mandate law unless a law was passed in its stead. And even up to the 1980 Foundations Law, where they made reference to the fact that there is now Israeli law, the older mandate law was still applied, unless there was an Israeli law which usurped that mandate law. Well, I guess I wrote that down, unless you have a newer Israeli law. We'll see what that means in a second, because they did pass a holy places law after 1967. But the point is that the ordinance would still apply. So, for example, the Holy Sepulchre the jurisdiction of the court cannot apply to the Holy Sepulchre. So you had the famous case that I did address beforehand. It actually was a case where the Ethiopians, it was between the Ethiopians and the Copts in the I believe it was 1970. The Ethiopians actually took the key from the Copts, opened the door, went inside the gate that you're supposed to open as part of a ceremony, locked it, and said that, we're not doing this. This is now our right under the status quo. Right meaning not just R-I-G-H-T, but R-I-T-E, I guess, as well, if you will, double entendre there. But the point is that they were trying to alter the status quo by themselves by acting, and it actually, they went before, they tried to challenge it before the Israeli court. The Israeli court had to dismiss it, because they said, look, we can't deal with these things. This is a status quo issue. We have no jurisdiction here. And it happens time and time again with regard to a variety of, if you will, holy places, capital H, capital P, where, I don't know if you're aware of the Israeli structure, but many times the court in Israel is not just a first resort, meaning you have the right of application before the Israel Supreme Court as a first form of application if it's involving a governmental actor. But what's important here is because the court in Israel is many times the last resort to go to as a means of either upholding policy or some form of right, due to the fact that it might be highly political, or that the political parties, I guess, or the government doesn't want to take any action with regard to that. So what happened many times is they couldn't deal with it. They actually tried to form a governmental commission to deal with the Ethiopian Coptic tension that was going on there. But be it as it may, the courts couldn't deal with it. I wrote down here, note the commissions of inquiry. What happened was that they never set up the commissioner for holy places as intended by the mandate. You saw that in Article 13 and Article 14, and subsequently in the order or in council. But what they did do, interestingly enough, were a variety of different commissions of inquiry that were set up by the British under the mandate as a means of dealing with a variety of different holy places. Again, capital H, capital P. Sorry to emphasize that, but I just want to make sure you understand what I'm talking about when I say holy places. The commissions dealt with different aspects of who controls and how to deal with it. I mentioned Mount Tabor because that is a really important place, Mount Tabor. In fact, that's part of the negotiations that are happening now between the part of the financial arrangements and property issues that are happening now between Israel and the Holy See. Is Mount Tabor is a central issue because it's not just I guess it's a monastery or a church monastery on top of the mountain, but also the church is claiming all the land that goes down the mountain too, as a means of saying it's holy as well. And they're engaged in different property issues as well. It's not related to this lecture, but I just want to point out that they did have commissions of inquiry that dealt with, for example, important places, holy places like Mount Tabor. Other rights that are important here, as I said, access and prayer, and they have been upheld. What I mean by that is that the issue of access and prayer, and again, I'm using, it's a legal context, the right of access, the right of, I call it worship, prayer, whatever you want to call it, whatever language you want to use, has been upheld by the courts. In other words, if you have a status quo place, or if you have a holy place, capital H, capital P, that is dealing with an issue of right of access, that is dealing with an issue of right of worship, the courts will get involved, because the notion is that the right of access, the right of worship, is inherent, is in the newer form of legislation, meaning is the post-mandate Israeli context of providing for the right of freedom of access, the right of freedom of worship, and as a result, the courts will get involved to deal with issues of access and prayer. It does not mean that they have jurisdiction over the site itself. They're not breaching the status quo. The status quo still survives. The notion of, and the mandate laws, the notion of saying that the courts don't have jurisdiction is to deal with issues vis-a-vis the site. But if you as an individual are saying, hey, I have a right of access to that particular area, I have a right of worship in that particular area, they will get involved. And I should say the other key aspect, and this again was reflected in, if you remember that article, that 1924 Order in Council, public order and security. In other words, the court will act on the basis of you dealing with right of access, dealing with right of worship. That's an issue that we could deal with. That's in the law. That's in the Israeli law. That usurps any type of restriction that we might have had beforehand, that we can deal with those issues. And they do. As well as dealing with, or I should say, counterbalancing against, which sounds terrible in a rights context, because there's really no balancing in rights, but let's call it as limitations, to use the vernacular, if that brings nightmares to you guys. But limitations, public order and security, are limitations that can be imposed on rights, provided for, by the way, in the international human rights context, for example, as grounds for saying, well, we have to limit your right of access, we might have to limit your right of worship at this particular time on the basis of public order and security. And of course, it's meant to be proportional and necessary, pursuant to the guidelines that are provided for. I'm referring to international human rights context, but it's entrenched also in a variety of different domestic orders as well. I throw down here the Temple Mount. We'll deal with that a bit later, I hope. We should have enough time. Because, for example, there's many times where Jewish groups, and this is becoming more profound as time has gone on. But certainly in the 80s, there were a variety of different Jewish groups that tried to access the Temple Mount to pray. Whether that was a right or not under international human rights, for example, freedom of religion, I would assert probably not, in the sense that there's no necessity to manifest. Nowadays, some have made the contention, you're going to laugh at this one, but it's seasonal, so I may as well mention it. The sacrifice on Passover, which was last week, many have contended that that should be done in the courtyard of the old temple. And that's where it should be eaten. It should be slaughtered and roasted and eaten in the courtyard of the temple. And many have said, they're trying to assert as a means of manifesting their right of access, manifesting their right of worship. Be it as it may, the court then says, well, there's also an issue of public order and security. So the majority, if not all, of the attempts to access the Temple Mount by Jewish groups, for example, just by way of an example, have generally been stymied on the basis of the public order and security, that it would either lead to some crazy outbreak of violence or tension between the two different sides, particularly between Muslims and Jews type of thing, Israelis and Palestinians. Okay, there's another aspect that I want to touch upon with regard to the Israeli context. So just by way of explanation, so this is kind of where Israel stands with regard to, at least till 67. And then after 67, we also had the Holy Places Law, which I'll mention. I actually erased it. Now I see why I put it in there, but I don't want to jump too far ahead. In any case, what you're seeing so far is status quo, the concept of some type of special, shall we say, treatment of holy places, capital H, capital P, but yet also allowing for right of access and worship with limitations based on public order and security. All right? After 1948, Israel had a lot of abandoned property in its country. And what they did is they passed what's called the Abandoned Property Law. And this is a means by which Israel acquired control. And you should know that it was done by Jordan, done by Jordan as well until 1967. And I found it being done by, interestingly enough, mainly an occupied territory type of context. Cyprus did it. North and South Cyprus, each side have their own abandoned property laws. I've seen it done with Nagorno-Karabakh in Azerbaijan and Armenia. They also have imposed what's called abandoned property laws. Basically, the idea of abandoned property law is, and I've seen it in other, if you will, more advanced European societies. I don't know, whatever that means, but they have the abandoned property laws of if there's a whole-scale abandonment of property. Property is kind of linked to the notion that you want it to be used. You don't want it to just sit there and be dormant. Principally, actually, it derives from, not derives from solely, but at least in the Israeli context, from the Ottoman principle. Under the Ottoman land laws, if you don't use it, you lose it, basically. And that's obviously a rough summation of the Ottoman land laws. But part of it was that they had to feed the empire. So you wanted to use the land as much as you could, especially in an agrarian-based type of context. And what happened was that in Israel, post 1948, this is part of the Nakba, part of the Nakba, protests that go on, is that there was that people ran away for a variety of different reasons, which is another lecture, I guess. And there was whole-scale abandonment of property, and Israel passed a law which basically said that if the individual was the owner, or even some of the owners, they actually did it for if there were a number of joint owners, if it was just some of the owners, were not found in the country after a certain date. I believe it was June 48 or something like that. They passed it as a provision on the 1950. They entrenched it into law. Then it was supposed to be held by a custodian for abandoned property. And it was held by a custodian for abandoned property. And there was widespread expropriation on that basis by Israel as a means of taking over a variety of different lands. I should also add is that on the basis of a land ordinance from the Order in Council allowed for expropriation for public purposes, public parks, things like that, laying down sewer lines and stuff. Israel used that as well. Again, I'm mentioning that because not that it's holy property, but a lot of it was church-owned land. And what happened was that now, with the negotiations between the Holy See and Israel for the financial arrangements, they're dealing with a lot of what they've done now is they've issued Israel like 99-year leases on land that Israel expropriated in turn for public purposes. Like there's different parks outside the old city, between the Dung Gate and Zion Gate. There's a huge park that was kind of church-owned land, but it was abandoned at the time. So there's all these different things. It was expropriated at the time for public purpose. The church was upset about, so Israel is trying to appease, and they've gone into different types of arrangements as a means of dealing with that. Well, it's also what happened was that under this abandoned property, obviously you had a lot of waqf assets. Waqf being a form of holy property, not holy places, capital H, capital P, but certainly a notion of religious property that's meant to be held. And what happened was the Israeli policy, shall I say, tried not to take hold of the variety of different waqf assets that were abandoned. What happened was that the Supreme Muslim, it was a Supreme, I forgot the exact term, Supreme Muslim Council is a weak interpretation of the higher Muslim Council, Supreme Muslim Council. They controlled a lot of the waqf assets during the after 1948, pre-1967, for example. pre-1948, sorry. And then after 1948, they ran away. So Israel deemed them to be, for example, abandoned property, and what they did is they set up then their own Muslim council to I want to say control, but to deal with the Waqf, meaning to at least try to distribute the funds of the Waqf as it was meant to be, usually charitable trusts for the benefit of the people, for agrarian purposes, whatever, poor, and all this different stuff that they have. The contention is that these sort of Muslim authorities they tried to take local people and deal with the Waqf. The contention was that they kind of were in the back pocket of Israel. I think that's partially true on a certain level because they took people who stayed behind, so they clearly were in on it. And it's not entirely clear what happened, but we'll get to East Jerusalem in a second. Then they had, I hear no Ministry of Religion versus Foreign Affairs Ministry, or what you guys would call your State Department is our Foreign Affairs. Ministry of Foreign Affairs. There was a major tension between them because Ministry of Religion, what happened was when they set up these sort of in place of the higher Muslim or Supreme Muslim Council, so it was all under the aegis of the Ministry of Religion. So they were controlling large tracts of land. And then they would, of course, divvy it up to the local Muslim councils to deal with it and deal with the Waqf. And what happened many times is that the local Muslim council would say, oh, well, we can't really deal with this. It's a bit too beyond us. We're going to give it to the custodian who will then sell it to the development authority under the control of the Ministry of Religion, and then they'll deal with it as they wish. So you're talking about really, it's a notion of power, it's a political power as well. And the foreign ministry used to get really upset at them, still does in certain levels, and says, what are you doing? This is not the right way to deal with the Waqf assets. And it was this ongoing tension, certainly through the 50s and 60s, and carried over post-67 as well, 70s and probably partial 80s as well. So you had that tension happening here, was that even though the abandoned property law was not meant to cover Waqf assets, in the end they kind of did, post-48. In 1965, they actually made a change to the abandoned property law, and they actually included Waqf assets into the abandoned property law. Why? Because what happened was that there was an old, and it's not to get too technical, but I think you guys will find it interesting, there was an old Ottoman law which allowed for Sharia court jurisdiction over Waqf assets, that if the Sharia court declares that they don't like how the Waqf was being divvied up or distributed, they can actually appoint their own custodian. I'm using the word custodian, but their own, sort of overseer of the Waqf. And Israel, what happened was that till about the 60s, with the lifting of restrictions on the Arab population post-1948, there were a variety of different restrictions imposed. So they were becoming, if you will, more active and assertive. Israel was also a little bit concerned. By the same token, they made changes to the abandoned property law with regard to Waqf assets, believe it or not, to appease a lot of the Muslim population, because the Muslim population felt, until '65, felt that the assets were not being dealt with properly, and they felt that it needed some type of overseer. So the government said, okay, well, we'll take over and help out here, kind of thing. And they actually were many of the Muslim Muslim population were satisfied with that, for better or for worse. I'm not saying it's perfect, but that is what happened. But they were concerned about the Sharia court becoming more assertive, which they were doing. So in any case, you had some control of Waqf assets, even from 1948 or 1950 onward, and carrying through until today. Now, the application to East Jerusalem, I have that down there. Obviously, we're talking about post-67, if I'm using the term East Jerusalem. I should say is that, well, you had East Jerusalem before under the Jordanian. Jordanians kind of took over the Waqf assets, by the way. They passed their own laws, but I'm not dealing with that right now. Application to East Jerusalem, what happened was that Israel declared that they would not apply the abandoned property law to East Jerusalem. Nevertheless, what happened many times is similar to what I said, is that they'd have tracts of land that they were not sure what to deal with, or that the custodian said as well, custodian for abandoned property would say as well, development authority would say as well, we really want to develop these tracts of land and they're empty and the guy's not here, it's East Jerusalem, we'll take them for ourselves, or we'll give them to different people. Generally not applied, I should say, however, to Waqf. Generally not always, but generally not. to Waqf in the East Jerusalem, meaning that it was applied, the abandoned property law, I could tell you right now, I'll show you examples, was applied to East Jerusalem, but not in the context of religious property, which is the focus of our talk today. So I just wanted to point that out, that the application to East Jerusalem is kind of strange in a certain way, but it was done. I wanted to give an example of how the abandoned property law was applied, the famous Mamilla Cemetery. It was an extremely famous historical cemetery. It was apparently, I think Salahadin's grandson or one of his famous generals was buried there. So we're talking about a really old, important historical cemetery. However, it was dormant, it was unused, probably for about 200 years. And there was actually a parking lot on the cemetery, owned by local Arabs. They were using it as a parking lot. And that's why I put down as unclear religious status. I'm sure Qadi Natur, who issued a decision in the Sharia court, would get upset at me, but we talk about this all the time. He's the president of the Sharia court, and he issued a whole bunch of different decisions with regard to the Mamilla Cemetery, which were then challenged before the Israel Supreme Court, and they changed it for different reasons, which I'll talk about a little bit about, time permitting, but I want to just get through some more slides. But when I say unclear religious status, what I mean to say is that there's this huge debate with regard to cemeteries, because of course cemeteries are holy. You're dealing with, especially in the Jewish and the Muslim context, they're extremely. It's not so easy to stop being a cemetery, and there's tons of them all over the place. And so part of the policy under Sharia law is to say as well, if it's over 25 years not used, the bones have turned to dust, and there's a certain amount of time, and you issue an edict. You could say a firman. You could say is that you can now use the cemetery for commercial reasons, for other reasons, if there's a need for it. And that really, I have to say, that really depends on how you interpret that, as anything else in the law, right? The law is subject to how, I guess, your best lawyer that you can hire. And what Israel did many times with regard to cemeteries, particularly Muslim cemeteries, like on the Tel Aviv beach, for example, there was an entire Muslim cemetery, that whole area where the Hilton is. And I'm not putting it down or saying it's good, but what they did is they had a firman. A firman was issued, and then as a result of that firman, they then built over the cemeteries. The firman saying is that, it's been over 25 years, it's not been used, the bones have turned to dust, and therefore we don't, you can't worry about it. What Israel did do is they preserved about 10 graves near the Hilton Hotel in Tel Aviv, for example, in deference to the importance of the individuals who were buried there. Whether that's good or bad, I don't know, but I'm just telling you this is what happened. Ironically, what happened with the Mamilla Cemetery was they had a similar firman issued, and the Museum of Tolerance, of all places, wanted to build their tolerance museum on a cemetery. Go figure. Right? Only in Israel, these weird things happen all the time. Right? So you want to have this notion of tolerance being imposed, or at least hopefully imparted to society, and yet you have a museum. And yet it's being built over a cemetery. And there are a whole bunch of different proposals. The Museum of Tolerance, actually, I think it was Frank Gehry was the original architect, and he pulled out because of this whole controversy. And they spent about $10 million on planning alone, with the architects and with the proposals and plans. And I think I personally think what happened with the Museum of Tolerance is they got to the point where they couldn't pull out because they spent so much money. I think they would have just, they couldn't do it. But they were challenged before they were challenged. Before the Supreme Court with regard to this issue. And like I said, it was on the Mamilla Cemetery with that firman. And there's a whole bunch of different aspects that came out of that. Basically, it was based on in a nutshell, and I'm giving you a very, very small nutshell. It's about a 150-page case, 100, something like that. It's basically the idea on the laches, L-A-C-H-E-S. Yes, yeah. That's a notion. That's an equitable notion. Is that if you delay bringing an action, then you lose your right of bringing that action. And the contention is that it's unclear whether there is an action here, and because they delayed so long, meaning that it was a parking lot, and I'm not exaggerating. It was a parking lot for 60, 70 years, even pre-state, and there was some construction there as well. And nobody challenged it then. Why are you challenging it now in the Museum of Tolerance? It's a notion of laches, and therefore you delayed long enough that you lost your right to challenge the fact of the buildings that are going to be put on the cemetery. Whether that's good or not, I don't know. I can tell you that the Sharia court itself, meaning the Qadi Natur, for example, issued to say is that you can never ever turn a cemetery into anything else. He gave a very strict interpretation of the perception of transferring a cemetery into other types of other types of usage. But be it as it may, that's the issue that was there. I just wanted to show you. Now, why am I saying this? Is because how was this Muslim cemetery, how was the Mamila cemetery, turned is, what they did is, they said, okay, you have this parking lot here, but the rest of it, the parking lot was sort of like this square here, and you had this whole big tract of land here, which was not used. So what they did is they said, well, this tract of land right here is abandoned property, and we're giving it to the custodian to watch over. Again, even though it's religious property, they said is that it's still abandoned, nobody's using it, and we have this firman which says is that, hey, it's a Muslim cemetery, it doesn't matter if it's after a certain amount of time and everything's turned to dust. So I guess they took the Christian ashes to ashes, dust to dust. I don't know. So they took this big piece of land and they gave it to the custodian for abandoned property. Custodian for abandoned property says, okay, this is great, we got this piece of land, let's give it to the development authority. Development authority then will divvy it up, and that's how, in essence, that's how it's turned over into regular use land. That's the legal avenue of how it's done. So I just wanted to point that out to you, how it got there, so to speak. One other thing to mention with regard to legal regulation, maybe we'll go in Q&A. I don't know, an hour is fine to talk. I don't want to talk too much, I could keep on going. But okay, I wanted to just point out the Holy Places Law because it's interesting with regard to what they try to do. The Holy Places Law does not usurp, does not overrule the jurisdiction, the mandate law, getting back to our first couple of slides, which is removing the jurisdiction from the courts. What it does do is that it says is that you have to uphold the dignity of holy places. Now, because it's a new law, 1967 or 68, because it's a new law, so the courts then have jurisdiction to deal with those type of issues under that law. Free access, worship, upholding dignity. Right? Somebody scrawls something on a grave or throws a head of a pig, which actually happened on a grave, or really sad things. Or upholding the dignity itself, there's too many people there, whatever it is. So you can challenge it before the court under the Holy Places Law. And the Holy Places Law calls for regulations to be drafted to delineate which places are, capital H, capital P, holy places. Specific, important, historical holy places. That's stuff that we saw.
That hadn't been clearly defined up until that point?
It's still not defined until today. There's no definition of what a holy place is. I'm just extrapolating from, for example, the mandate ordinance or the commissions of inquiry as to what would be considered capital H, capital P holy place, meaning it's historically known, constantly visited, pilgrimages are done to it, pray, stuff like that. People pray to it, they go to the pray for, I don't know, their spouse or get married or who knows what, stuff like that, you know what I mean? But it's not like your typical synagogue or church. So it's a historical notion. It has some type of veneration that's recognized by the relevant religious sect or group. You hear what I'm saying? So even in this law, that's kind of the irony here. This is why, by the way, we started doing this stuff, is because I was thinking, well, there's got to be some definition of holy place somewhere. There's not. There's no definition. You have to just extrapolate it from, kind of in a common law type way, extrapolate it from the cases or decisions. But even then, the decisions are rather sparse, and they're very wary of saying what is a holy place. But they did say is that regulations are to be drafted, not to define holy places, which would have been nice, by the way, good question, but at least to delineate which sites are holy places, capital H, capital P, and therefore have his special veneration, if you will. So what they did is they started doing that, but they only focused on Jewish sites, and they only have very few particular, I think they have 10, I don't know how many I listed here. Shimon Bar Yochai, Western Wall, its surroundings, Cave of Shimon, the Just, that's actually in Sheikh Jarrah, in East Jerusalem. The small Sanhedrin cave, tomb of the rabbi of Avijah Bar Tanura at the Mount Olives, that's also in if you will, post-67 territory. Zechariah's tomb, Absalom's monument, which is also, that's in the Silwan. So you have all these different areas that were protected, and if you notice, it's actually very few, even of the Jewish sites, by the way. There's a whole bunch that are not included. The reason for that is because, again, the internal struggle between the Ministry of Religion, which, by the way, has since been disbanded, is now Ministry of Tourism. There's no more Ministry of Religion in Israel. And the Ministry of Justice. And what I'm getting at here is that the regs have to be passed by both Ministry of Religion/Tourism and the Ministry of Justice. And many times the Ministry of Justice says, no, we're not going to pass these. We don't want these. We feel they're, unfair, or they're in occupied territory, or for whatever legal reasons they have, they drag their feet, or they're more secular, if you will. So that's why you have very few regs issued. That's the internal struggle. And then I have the external struggles that has never been applied, I should say Muslim/Christian, forgive me for that one. It's not applied to Arab sites, meaning Israeli Arab sites, in Israel. And there was a 2005 petition of Adalah to move ahead and to draft regulations for the different Muslim sites that are considered capital H, capital P holy places, but it has not been forthcoming. And the petition was kind of denied because it's basically the court saying is, well, you can't ask us to force the government to do something that's beyond our power, but they did recommend and things like that. So that's just the reality of relying upon a judicial system too often, I think. I was going to go to the West Bank a little bit. I don't know if we have to do that here, but I'll just mention it really quickly. Basically, they have West Bank is military context, so they mirror Israeli law. So basically, they have a military directive, which is the Holy Places law, just copied on to a military directive. And there are many. What's interesting, the reason I wanted to mention that the West Bank is because I thought it was my shoelace here, but it's because you have shared sites. And that's, again, another thing. You think that it would be awesome to look at shared sites, right? Shared sites. Wow, look at that. We're all working together and living together and kumbaya. But nobody really has done that. Nobody's looked at shared sites, and I believe that's a real shame in a way. Hebron, I'm mentioning the Cave of the Patriarchs and Matriarchs is a shared site. There's a synagogue on site, and there's a mosque on site. Rachel's tomb is the same thing. You have the mosque on top and the synagogue down below, next to the tomb itself. So these are shared sites which have been going on as shared for quite a long period of time, hundreds of years. And good or bad, it works. I'm just mentioning that is because they did have some cases, recent cases. I don't know if it's so relevant to us, but just basically they have different cases with widening of a road to get to the site itself. Rachel's tomb was similar, was more of a creating a protective road because they were sniping on, particularly it was Jews who were coming to visit Rachel's tomb were being sniped upon or rocks thrown. So they built a big wall there, a corridor to allow it to be done. And they were challenged before the court. The court actually, in both instances, kind of changed, requested the army, and they did, to change it a little bit to reduce the tension on the civilians in the area. There was reparations. It wasn't just taken. But basically the court said it's a notion of public order security versus property rights in the case of the Hebron case, whereby they had to allow for a widening of the road. And here it was, again, public order versus movement and property. There was, I guess, Michael, you know about that case in particular, but that's what it was with regard to it. I'm not going into it too much, but I'm just mentioning it in the interest of time. Generally, and then I think I'll stop here. What else do I have here? Oh yeah, the Temple Mount. If you want to get into the Temple Mount, I'm not sure if you guys want me to go on. You might be getting tired of hearing me talk, but generally the court withholds jurisdiction on the key holy places. Certainly, and the key holy places, capital H, capital P, for example, Temple Mount is considered a key holy place. Court said what challenge before the court was, hey, it was never a regulation. If you notice that there's regulations that I showed you before under the Holy Places Law, said the Western Wall and its environs didn't include the Temple Mount. They will not touch the Temple Mount for a variety of different reasons. Nevertheless, the court said is that it's obviously a holy place. We don't need a regulation for that one. I mean, it's a no-brainer, and we don't have jurisdiction over that. Unless, I'm emphasizing, unless it's a right of access to worship or an issue of public order and security. Then the court has jurisdiction under the law, and it will make these determinations based on that. And that's the right, and generally you're having that right of access to worship versus deference to the authorities. The Solomon Stables issue was an interesting one, whereby it was the Waqf was built another mosque, and what they do is they dug underground by the Solomon Stables area, and then kind of just dumped the ground. And this is like, from an archaeological perspective, forget even religious perspective, it's a bit of a shame what was happening, and they tried to challenge it before the court and stop, and the court said, well, we can't really. It's on the Temple Mount. It's out of our jurisdiction. You have to go to the authorities. And they tried to negotiate and this, that, and the other. Nothing really happened, but whatever. I also want to point out the aspect of, generally, notion of creation of new places. And that's, I mentioned here about the Cave of Nachmanides. That's right next to Simon the Just. Simon the Just as being one of the regulated holy places in Sheikh Jarrah. They found also a cave where supposedly Nachmanides would pray and sort of meditate in or something like that. And it was nothing. It was, I think it was owned by a local Arab. And it was at times used for different things. One time it was a parking lot, one time it was something else, but it was nothing. And then it was an Israeli Jewish NGO tried to lay claim to it. And actually they had a governmental commission which allowed them to establish there some type of prayer place in the cave of Nachmanides. But just to show you, is the creation of new places. What I'm getting at is that there's, because, as you asked me quite shrewdly, the fact of lack of a definition of holy place, so there's this push to create new places to say, oh, you see, this is also an important place. This is also historically significant. And oh yeah, look at that. That guy's buried there, and that guy's buried here. So it's that notion of pushing the boundaries, so to speak, to create new places. And then the chilling of relations. And then I'm getting at is, and I guess I should talk about Temple Mount real quick, but in the Temple Mount context, you're dealing with Israel doesn't have, quote unquote, I don't know if it has sovereignty. It probably has sovereignty over it, but it doesn't have control. It does not assert control over the Temple Mount. It's run by the Waqf itself. And for a long period of time, the Waqf had very good relations with the Antiquities Authority of Israel. So, for example, before the Solomon Stables issue, they actually had very good relations, and they allowed for them, if they're doing digs, they allowed the Antiquities Authority to come in first. That's what you're supposed to do under Israeli law. Under the Antiquities law, it's another aspect I didn't deal with. But you can see you could dig deeper, no pun intended, and find other laws as well. But the Antiquities Authority, basically, their relations have cooled with the Waqf for a variety of different reasons, and the ministries as well, because it got really political. Plus, on the Temple Mount, you have which Waqf controls. For a long period of time, it was the Jordanian supporting the Waqf workers, paying their salaries and any type of overhead that was needed. And then when the Palestinian Authority rose to the fore, they started paying their own Waqf guys. So we got into this whole contention there. I think I'll stop here and get Q&A, because I saw people writing stuff down, and there might be some good questions. So we could deal with this maybe afterward or in the course of the Q&A, if that's okay. I think that's a good idea. I think it's enough said. So let's take some questions.